All right, let's bring in our legal guys. Avery Friedman, a civil rights attorney and law professor in Cleveland. Good to see you. And Richard Herman, a criminal defense attorney and law professor, joining us from Las Vegas. Good to see you as well. All right, so, gentlemen, let's look at the evidence allowed in and evidence barred. Allowed in, the prosecution has a marijuana joint found near Lloyd's body with Hernandez's DNA, a .45 caliber shell case found in a car Hernandez had rented, a footprint that matched sneakers worn by Hernandez, and his home surveillance video, and some texts, Hernandez's text to Odin Lloyd. But then the judge barred this key evidence, or at least what some thought would be key evidence, Odin Lloyd's text to his sister sent just minutes before he was killed, suggesting that he said he was with NFL. Any mention of Hernandez's involvement in the shooting of 3 other men that he suspected of, and a 2009 photo of Hernandez holding a gun. So those things barred. So Avery, you first. How significant is what's allowed in thus far and what isn't?
Well, the evidence, Frederica, is overwhelming here. Judge Susan Garsh is exactly right in barring certain prejudicial evidence, but at the end of the day, the evidence is so strong, including motive, meaning the position that prosecution is taking is that the motive behind this murder was that Odin Lloyd disrespected Hernandez, and that's going to be part of it. Secondly, the joint venture theory. The prosecutors don't need to prove that Hernandez pulled the trigger, but rather, Frederica, all they have to show is he actively participated in this. So while we only have the first 2 days of trial in a case that will last 2 months, the evidence at this point looks like it's going to be extremely strong, very difficult for the defense.
So wait a minute, Richard. Okay, so Richard, I want you to respond to that. So they don't have to prove that Hernandez actually pulled the trigger, actually committed the crime, even though he's up for murder, but instead, all they have to prove is that he was there, that he may have been an accomplice. Is that right?
That's exactly right.
That's on that theory for murder. They charge him with first-degree murder, so they have to prove that he intended to kill this individual. But Fred, there are more things than footballs deflated in Massachusetts these days, and that is the prosecution case here. They do not have an overwhelming case, Avery. They do not. They do not have the gun that was used. They do not have the gun that was used. They do not have any witness to say that he was there when the murder took place. They have no videotape of this, no audio tape. There's 2 co-defendants. Neither one of them are rats in this case. The prosecution, although you would think when you open a trial up, they would put on an overwhelming introductory case. So far, fizzle, 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 Fred. I'm telling you, they got great attorneys for the defense here. Reasonable doubt is splashed all over this case. Why would a guy who's making $40 million a year plan to kill a friend, kill him near his house, leave him there, leave the body there, and then leave his home surveillance system on if this was a planned murder? This is a very difficult case to prove, Fred. I would not be surprised a jury comes back and says the prosecution failed here.
And you feel that way despite this video, this surveillance video that we see. Some say it looks like a gun, but I guess that's disputable too. So Avery, if no gun, I mean no murder weapon, and you heard the defense attorney say there was no real motive, and as you heard Richard say, why would someone throw this away? $12 million contract, that's what so many have said. Then, you know, how does the prosecution try to convince the jury that yes, there was motivation, and yes, he was there, no murder weapon, but he was the one who, you know, cost Odin Lloyd his life?
Well, the answer is that most cases are established by circumstantial evidence. Most cases. And in a case like this, the evidence, for example, of 4 people going to the site and then 3 people coming back, along with, there is motive evidence, the idea that Lloyd, quote, disrespected, unquote, Hernandez, and the fact that he was earning $40 million a year, at least potentially, I think assumes that Hernandez actually thought this thing out deeply. He didn't. This was a stupid, reactive
But isn't it remarkable?
action.
No one has talked. There's been no information as a result of any kind of offered plea deals. I mean, it is silent.
It's amazing, Fred. It's amazing that the co-defendants have not rolled in this case. They couldn't get anybody to roll. They're all standing strong here. It's going to be a very, very difficult case for the prosecution to try to link together circumstance here when they don't have it. I don't see it, Fred. I really don't see it at this point in time. And, you know, there are other cases down the pipe here. He's also going to face a double murder
coming
case
up
after this. But none of that's admissible in this case. The jury, exactly. They don't know anything about that, supposedly. But here the defense is similar to the O.J. Simpson defense. They're saying the prosecution targeted him, tunnel vision, they went after him, they didn't investigate, and that happens a lot, Fred. It's happening to me and one of my clients now. It happens a lot. Tunnel vision. Yeah, I think so.
Okay, this is one to watch
We'll
indeed.
see.
Avery, Richard, thanks so much, gentlemen. Always great to see you.
See you soon. Take care.
All right,
hey, Fred, I hate both teams, but we're going for the Patriots.
Oh, you are?
Both,
okay, all right. Well, you know, proximity means something.
If Tom Brady's not a crook, let's go for the Patriots. Okay.
Okay, well, we'll see how it all plays out. Thanks, gentlemen. Good to see you.
Take care.
All right, tonight there's more talk of Aaron Hernandez.